Officer Dade, would you open the courtroom, please?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Morning.
We are on the record calling file number 1106761. The file is entitled Asset Acceptance versus Phyllis McKay. Date and time for objection to garnishment, your appearances.
Good morning, Your Honor. Elizabeth Smith, P63010 for the plaintiff.
And what is your name, ma'am?
Phyllis McKay.
You are the moving party. What is the basis of your objection to garnishment?
This debt that Asset Acceptance is seeking to for me to pay is a debt that I acquired over 25 years ago, and it has gone from different collection company agencies over the years. And just recently in 2018, I was garnished through wages that totaled $1,611.08. The debt was they're saying that the original debt was $3,410.37, which it was not that amount when the account was charged off by Comerica Bank. That is just a buildup of interest charges and court fees that they have added on. And so I have paid different amounts over the years towards the debt, which now they are saying that the interest is way more than the debt was initially. And so I find this to be, unjustifiable that I should have to pay $6,000 to a collection agency who, this debt was not originated with, just because they are sending it to court and doing different things just because they purchased the debt. The debt has been charged off by the original company, and I have made payments over the years. Like I said, they recently garnished me in 2018.
Ma'am, what do you claim you paid in total on this judgment?
I'm sorry?
What is the total amount, ma'am, that you claim you have paid?
What is the total amount that I have paid?
Yes, ma'am.
Okay, well, I have to say I haven't kept up with it over the years, but according to the documents that they sent, that I've paid $1,611 most recently. But like I said, this debt has been passed from collection agency to collection agency. So each one is giving, maybe giving different amounts that I've paid. Maybe they're only giving the amount that I've paid them. Unfortunately, I haven't kept accurate records of how much I've paid the various companies over the years, but I still cannot understand why I would be required to pay $6,000 for a debt that may have originally only been about $1,000 or maybe $1,500. I can't even remember. It was over 25 years ago that I established this debt.
All right, let's hear from Ms. Smith.
Thank you, Your Honor. It does appear that the judgment was entered for $3,410.37 in June of 2011. To date, we have received $1,681.08 in payments. And due to the statutory interest, we do show that the current outstanding balance is $6,168.77. It sounds a lot like this may be an attack on the underlying judgment. Perhaps there was an issue with the dollar amount at the time that the judgment was entered, and just unfortunately, an objection to garnishment is not the appropriate vehicle for that type of contest. based on that, plaintiff is asking that the garnishment be allowed to stand.
Is there anything else you want to say, Ms. McKay?
What I've said so far, I don't know what else to say. I'm just asking, that this, garnishment not happen, because I don't understand why I would need to pay $6,000 for a debt that wasn't nearly this amount.
All right. Court is prepared to rule in this matter. Michigan Court Rule 3.101K specifically provides that you may not use the objection to garnishment form to challenge the validity of the underlying judgment. So we have to start with the judgment as is. Whatever may have happened prior to that is not relevant in this case. In this case, ma'am, on June 16th of 2011, a judgment was entered in the amount of $3,410.37 against you. That judgment bore the then statutory interest rate of 13%. That 13% continues until the judgment is satisfied. We are here today in 2021, almost 10 years from the date of that judgment. And just by way of example, in the first year alone, that $3,410 judgment would have accrued interest in the amount of $443, which would then be added to the base, and then it would be continued to grow interest compounds. So court finds that you failed to state a valid objection to garnishment. The objection to garnishment must be denied. You have, of course, an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Thank you.
I'll send out an order to both of you today.
Thank you, Judge.
Mr. Rusin,
Hi, Judge. How are you today?
good. How about yourself?
Oh, just living the dream.
What brings you here?
Well, funny you should ask. I have today a pretrial conference on your file 2016690, which is Credit Corp Solutions versus a Selena Brown.
Is that not on my calendar for today?
Well, isn't that something? Let's look at my notice here. Well, I'm looking at a half-slip opinion, what I call a half-slip opinion. It was issued on January 18, and allegedly it sets this for pretrial conference.
Give me the number of the case again, Mr. Rusin.
Are you ready?
Yes,
All right. It's
20
166
166
090.
090. Okay, let me check with my clerk to find out what's going on. I'll get back to you.
That's just great.
Wait, hang on, I got it here.
Oh, great.
Oh. February 11th. Okay, thank you.
Oh,
Mr.
you're
Rusin,
right. Yep, that's my bad.
February
Looks like
11th.
I got a free day today.
Oh, well then, use it wisely. And we'll talk to you then tomorrow.
All right, bye-bye.
Have a good day. So, All right. Let's see what we have here. Mr. O'Connell, you and Mr. Jarrett are here on,
Yes, Your Honor.
on the Auto Club versus Alexis Stevens Watts matter.
Ernest Jarrett for Ms. Stevens Watch, Your Honor.
Mr. O'Connell, is that why you're here?
No, Your Honor, I'm here on the Foster matter.
Okay, Mr. Voorhees, is that what you're here on the Foster file?
I am not. I'm here on Jessica Price.
Okay, so I don't have a pair.
Yeah.
Okay. I'm afraid I don't have a pair as of yet.
Yeah, I don't see her. She hasn't showed up
Okay,
yet.
I got somebody who just came in. Let's see who this is. Mr. Sotong, good morning.
Good morning, Your Honor.
What brings you here today?
Your Honor, I'm checking in on Automobile Club of Michigan versus Alexis Stephen Watts. This is case.
That I have a pair. So let's put everybody else, Mr. Voorhees and Mr. O'Connell, into my waiting room, and we'll get started on your respective motions.
Good. Thank you very much, Your Honor.
Your Honor. Your Honor.
Yes,
Before we get started, I just wanted to apologize to the court for my non-appearance earlier or last month. I would indicate to the court that it appears that the notice, our original motion was supposed to go in December and the court closed. We got a new notice. It was mailed to us. I've been working remotely, so I'm not in the office every day to see the mail. The week that the notice went out was the week that my wife lost her father, and I was trying to assist her both emotionally as well as in making arrangements. And then the week after that, I was in surgery. So I didn't actually see the notice until the day after the hearing was supposed to go forward. I apologize, and I appreciate the court adjourning it to today.
you should thank your opponent. I was going to proceed.
Okay.
That's why we
Thank
have
you.
notices, because your practice of not going to your office is your own business. But the court rules require us to send notice of things to your office. And that's the decision that you've made, so be it. Don't thank me, thank counsel, because I would have proceeded in your absence. Let
Very
me
good.
make it perfectly clear. I'm not a disc jockey. I don't issue requests, I issue orders. And we
Very
schedule
good. Yeah.
order, not a come on by if you want to. Let's call your case and let's get started on this file. We are on the record. This is case number 19178-038. That file is entitled Automobile Club of Michigan versus Alexis Stephen Watts. We have here today competing motions for summary disposition. The first motion for summary disposition was filed in lieu of an answer by the defendant. So we'll proceed with that first, followed by the motion for summary disposition filed on behalf of plaintiff. Your respective appearances.
Good morning, Your Honor. Christopher Sosson, spelled Sossong, P59383, appearing from Velo Law Office on behalf of the plaintiff.
Good morning again, Your Honor. I'm Ernest Jarrett, appearing on behalf of the defendant, Ms. Stevens Watts. She is usually also in this meeting. I haven't seen or heard from her, but
She's on the call.
very good. Thank
I
you.
see her. Good morning, Ms. Watts. Tell us your name.
Good morning. My name is Alexis Stephen Watts.
Mr. Jarrett, your motion.
Thank you, Your Honor. Your Honor, this is a motion for summary disposition brought pursuant to MCR 2.116 C7 and C10. With respect to the C7 aspect of the motion, under the rule, summary disposition is appropriate if the claim has been resolved either by payment, release, or other disposition of the claim before commencement of the action. Now, what we have here, Your Honor, is a situation where there was a minor accident between two vehicles. The drivers of both vehicles got out and exchanged information, my client being one of those two drivers. They exchanged information and then went about their way for that particular day. Shortly thereafter, my client was contacted by the plaintiff's subrogor, Mrs. Jill
The other
Robin.
driver.
I'm sorry?
Make it easy on yourself. The other driver.
The other driver, yes, Your Honor. She was contacted by the other driver and she said to her, she made an offer to her, and she says to her, if you will pay my deductible and take that amount into Mario's collision, then that will be all that I ask of you. And that exchange of information, that proposal, is supported by my client's affidavit. My client did, in fact, take the $550 deductible into Mario's collision and made payment, thereby completing her half of the bargain in this particular settlement offer. It is our position that once that was done, this claim was extinguished. The Auto Club stands in Ms. Hill's shoes as the subrogor and as the subrogee, I should say, and has no greater right than Ms. Hill has herself. And when Ms. Hill extinguished the claim, she also extinguished the Auto Club's right to proceed in this particular case. Now, my client's affidavit stands uncontroverted. The response to my motion really doesn't respond to whether or not there was a settlement agreement between the parties. So that goes as an admission, I would submit, by failure to respond in any way. My client's affidavit is totally uncontroverted. It stands alone, and therefore we have established factually that this agreement did in fact occur, and therefore this claim is extinguished and we're entitled to summary disposition for that reason.
All right.
I'm sorry.
I'm sorry. Go ahead, sir.
I was just going to say that in the alternative, while I submit very vigorously that my client is entitled to summary disposition and the claim should be dismissed, if for any reason the court does not dismiss the claim as we are requesting, then we submit that we're still entitled to summary disposition as to the amount of the claim. The Auto Club is seeking $3,526.92. By their own record, they only paid $2,976.92. Their record is attached to our motion. I believe it's Exhibit C, if I'm not, no, it's Exhibit C to our motion. And I think it's noteworthy that the difference between the amount that AAA actually paid and the amount that they're seeking is $550, which is the same $550 that my client took into Mario's Auto Club, Mario's collision, and paid on behalf of Ms. Hill in conformity with their agreement. So for those reasons, I would submit that the defendant is entitled to summary disposition. Does the court have any questions?
Yes, what is the amount of the mini tort threshold in Michigan as of the time of your client's accident?
I believe it would be $3,000.
Okay, thank you. Let's hear from the other side.
Thank you, Your Honor. Thank you, counsel. Your Honor, plaintiff did file its response in opposition to the defendant's motion, and it has set forth its position in that response. And briefly, it is plaintiff's position that that the fact that Miss Robinson remitted payment, or excuse me, that Miss Stevens Watts remitted payment to Miss Robinson does not extinguish the plaintiff's right to recover for benefits that it has paid under the no-fault statute. The argument made by defendant centers around the fact that the defendant paid a deductible of $550 when requested to do so. There are no details surrounding that discussion that there would be any agreement to extinguish any insurance claim that was pending. There are no additional details in support of that would constitute any terms or conditions of an agreement that all damages sustained by Miss Robinson in the accident would be extinguished by payment of the $550 deductible. In fact, in the motion for summary disposition filed by the defendant, she clearly sets forth that Miss Robinson asked defendant to pay her deductible in the amount of $550 and stated that if she pays that amount, it would take the amount directly to Mario's. That would be all that she would ask for from the defendant. And in fact, that is what the defendant, or excuse me, Miss Robinson would be entitled to from the defendant under the mini tort statute. And as plaintiffs pled, and as the facts of this case center around the fact that the defendant failed to maintain no fault insurance as required under the No Fault Insurance Act. So as such, Your Honor, it's plaintiff's position that even though the $550 was in fact paid, that did not constitute a settlement agreement of any and all claims, including the rights of the subrogee to pursue no fault payment of no fault benefits in this action. So that would be plaintiff's position, Your Honor.
Thank you. Mr. Jarrett,
I'm sorry.
did you wish to rebut?
I do, Your Honor. First of all, Your Honor, counsel makes the assumption that his subrogee, subrogor.
It'll make your life easier to just use the names and parties.
That Ms. Hill, yes, okay. He makes the assumption that she was automatically entitled to this money. Now, of course, she would have been entitled to bring a mini tort claim, and my client would have been entitled to defend on that claim and to contest that claim. And by entering into this agreement with Ms. Hill, my client, number one, waived any right to contest a claim. Number two, taking it into Mario's was additional consideration, which is not required by the statute. And number three, she expressly stated that if you will do this, that will be all that I ask of you. And so that is, I mean, these two women were not attorneys. They didn't execute a release with 15 different paragraphs and 13 different subparagraphs to each one of those. This was their agreement. You do this for me, I'm done asking you for anything. And so my client accepted that proposal. She not only paid the amount of money, which is the amount of the deductible, which is consideration. She waived any right to contest whether or not she was liable under the statute, that's consideration. And she took the money into Mario's, which is additional consideration. And so for those reasons, Your Honor, there was an agreement which is enforceable and binding upon Ms. Hill, and as such is also enforceable and binding on the Auto Club.
Thank you.
So,
Court is prepared to rule in this matter. This is a motion under C7 claiming there was payment, and C10 no genuine issue of material fact. We conclude evaluating a motion under C10. Court is required to be liberal in finding the existence of a genuine issue of material fact. There's only one affidavit here. The affidavit, the corrected affidavit of Alexis Stevens Watts. I'm quoting, "A few days after the accident, I was contacted by Ms. Robinson, who asked me to pay her deductible in the amount of $550 and pay it at Mario's body shop. She told me that if I did this, that would be all that she would ask of me." This is a claim. The amount of money is in the mini tort provision. That is the opportunity for a person involved in a motor vehicle accident to recover from the other driver monies not paid by insurance. According to what Ms. Alexis Watts said in her corrected affidavit, any agreement that the parties had was limited to her deductible. Therefore, the motion for summary disposition filed on behalf of the defendant, Alexis Stephen Watts, is denied. We have a motion for summary disposition filed on behalf of the plaintiff. Sir, your motion.
Thank you, Your Honor. Your Honor, we are here also, as the court notes today, on plaintiff's motion for summary disposition, and this motion is brought pursuant to MCR 2.116 C9, C10, and I1 for the reasons as set forth in the motion and attached brief in support. This claim, Your Honor, by the plaintiff arises out of an automobile accident that occurred on May 3rd of 2017. When the defendant was traveling eastbound and failed to stop in a short distance and caused a rear-end collision with plaintiff's insured's 2008 Chevy Impala.
Let me stop you right there. How do we know that this is a rear-end collision? There's no affidavit describing the term of the accident. The only thing that's in the record supported or provided by your motion was a police report, which is per se inadmissible. How do we get to rear-end accident? We get to an accident. Ms. Alexis Watts said I was involved in a minor accident in her affidavit, but there's no anywhere evidence here of what type of accident. Is this a rear end? Is this a side? Is this a head on? Is this a T-bone? There's no evidence here. Rephrase, no admissible evidence here.
We do have the traffic crash report itself, Your Honor.
Which is admissible. That's the point I'm making. The traffic crash report is by statute inadmissible. So where do we get to this being a rear end accident as distinguished from a head on or T-bone? Because your argument relies upon the statutory presumption that a rear end accident prima facie evidence of fault of the rear end striking driver. But we don't have any evidence. This is a rear end admissible evidence that this is a rear end accident.
Certainly, I do understand Your Honor's point, but with the proper foundation being laid by a witness testifying, one, that a traffic crash report could be admissible evidence at trial.
All right, let's assume that's possible. But we are not at trial. We are at summary disposition motion. And I am required to decide that motion within the bounds of the pleadings. Once again, I ask you, where is your evidence, admissible evidence under C10 that this is a rear end collision?
Well, I would again just offer the crash report itself.
Okay, and I've already made my decision on that. What else?
And second, Your Honor, I would point to the answers, defendant's answers to plaintiff's discovery request. And particularly In paragraph, I'm referring to.
Excuse me, I'm going to object to references outside of the motion that was filed. We responded to the motion as it was filed. There was no reference to any discovery answers or anything of the sort. And so I object to any reference outside of the four corners of the motion that was filed.
Your objection is noted and is overruled. The court rule specifically provides that pleadings and affidavits can be considered. What pleading?
I understand, Your Honor, but we have to have notice of what he's relying on so that we can respond to it.
Thank you, Mr. Jarrett. I approve. Mr. Sir, move forward.
That is attached as plaintiff's exhibit number 2 to plaintiff's motion. And specifically, I'm referring, Your Honor, to the request for admissions that the defendant answered and completed and served through the course of discovery. And if Your Honor, we do have in request for admission number 4, there was a request to please admit that on or around May 5, 2017, plaintiffs insured automobile sustained damage when you collided with it. The defendant's response is admitted. In paragraph number 6 of the request for admissions, defendant was asked to admit that she was negligent when she struck plaintiff's insured's vehicle. Her response is admitted. Paragraph number 7 of the request to admit, please admit that as a direct result of your failure to stop, plaintiff's insured's vehicle suffered damages. Admitted. Subsequently, paragraph number 8, please admit that on around May 5 of 2017, you were at fault in a collision between the vehicle you were driving and plaintiff's insured. Defendant admits that she was negligent, but states that the plaintiff's insured was also at fault. In paragraph number 10, please admit that you were issued a citation for failing to stop within an assured clear distance. Defendant again indicated she admits that she was issued a ticket. She does not recall what it was for. Plaintiff's argument, Your Honor, is that this claim is premised on a theory of negligence. The defendant caused the accident and was negligent in doing so, and as such is liable for the damage that she caused to that she caused to the insured that resulted in damages to the subrogate, the plaintiff. And so given the defendant's admission as to her negligence in causing the accident, that factually establishes the support, Your Honor, for plaintiff's claim for this motion for summary disposition.
Mr. Garrett, how do we get away from your client's response to request to admission?
Your Honor, I'm looking for those requests for admissions as we speak. I would note again that the plaintiff did not attach those to his motion. He says it's attached as exhibit something or other. If there is no such attachment to the copy that I have. Now,
my copy of his motions has no request for admissions attached to it either.
And so I submit that it's inappropriate for counsel to argue his motion based upon evidence which is not attached to the motion itself.
Then we'll stop right here. We are going to not decide the motion for summary disposition filed on behalf of the plaintiff at this time. If you wish to supplement your motion with proof of service and answer on these requests for admission, sir, you may do so. But Mr. Jarrett is in the same position I'm in. You reference things in your brief that are not attached as exhibits. So this is what we're going to do. We're going to give another date for the plaintiff's motion for summary disposition. I've already made my decision in relationship to the motion for summary disposition filed on behalf of the defendant. We'll send out an order in that regard. So let's get a date and let's move forward on this file. All right, today is February the 9th, the 10th.
Yeah.
All right. So if we give counsel 10 days to file his supplemental pleading, give Mr. Jarrett another 10 days, that gets us to early March. So how about we set plaintiff's motion for summary disposition for March the 4th at 11 o'clock. Does that time work for both of you?
Yes, Your Honor.
Mr. Jarrett?
I believe it does, Your Honor. If you give me 1 second, I'd like to check
Yes,
my
sir.
calendar. March 4 appears to be good, Judge.
Okay, then this is what's gonna happen today. I will issue 2 separate orders. I'll issue an order denying the motion for summary disposition brought on behalf of the defendant in this matter. I'll issue an order continuing until March 4th at 11 o'clock, the motion for summary disposition filed on behalf of plaintiff. Indicate further that plaintiff has 10 days to supplement existing motion. Mr. Jarrett will be permitted to respond as well. Thank you
Your
both,
Honor, if I could, before we leave,
sir.
one of counsel's co-counsel or another member of his office who's appeared previously had agreed with me that we could exchange all filings by email. And so I'm asking that anything he files be emailed to me if he would do so, please.
Is that agreeable to you, sir?
If that's what my colleague agreed with you, yes.
Yeah.
And I will agree to that.
File
Thank
with the court per court rule by snail mail.
Understood for
Right.
plaintiff.
All right, 2 orders.
And so will I
Jarrett?
file with the mail as well. I'm sorry.
Yes, Mr. Jarrett, if you choose to file anything once you've received his supplement, you can
Right.
email him, but you must snail mail me,
Very good.
okay?
And counsel, do you have our email address?
I believe it's on the pleadings, isn't it? And if it isn't, I'll contact you, but I think so.
Very well.
Okay, everybody.
Thank you very much, Your Honor.
March
Thank you, counsel.
11 o'clock.
Thank you,
for
Your Honor.
coming in. We are now off the record in this file.
Thank you.
All right. My motion, unfortunately, gentlemen, took a little longer than anticipated.
No problem.
We are calling file number 20240-589. This is Travis Foster versus Spirit Airlines, your respective appearances.
Your Honor, I'm not sure about Mr. Foster, but I am Tim O'Connell appearing on behalf of the defendant and Move It Spirit Airlines.
Mr. Voorhees,
I'm not on that case, Your Honor.
we have a problem. Mr. O'Connell, you're here on behalf of defendant Spirit.
That's correct, Your Honor.
Mr. Voorhees, why are you here?
I have a pretrial, I believe, today, Your Honor, for Jessica Price. If I'm not mistaken.
I think I need your case number because I don't have.
Yep. Give me 1 second, Your Honor. Let me switch my program so I can get into it.
Jessica Price has been settled, has it not?
It has. We just recently. We haven't even got the paperwork through.
I signed a stipend order dismissing this case the other day based on a fax that I got saying the case had been settled and asking me to take it off the docket.
I didn't stipulate to that,
Let me call my court clerk.
if I'm not mistaken.
Okay, in any event, I have an easy situation. I'm going to put you in the waiting room, Mr. O'Connell. You and I are going to do business, and we'll be just a second. Don't go away, Mr. Voorhees.
No problem. I'm right here, Your Honor.
All right, we are calling file number 20240-589. This case is entitled Travis Foster versus Spirit Airlines. By notice dated January 14th, 2021, this matter set for pretrial conference today, February 10th. Matter set at 11 o'clock. It is currently 11:34. What is your name, sir?
My name is Tim O'Connell. I'm appearing on behalf of the defendant and Move It Spirit Airlines.
And your bar number, sir?
74737.
All right, I don't have to deal with your motion for more definite statement. I'm dismissing this case for the reason that the plaintiff has failed to appear. No good cause for that failure having been shown. The file is dismissed without prejudice. We'll send you out a copy of the order, sir.
Without prejudice, Your Honor.
Yes, sir.
Very good, Your Honor.
If it
Thank
is
you.
instituted, you would of course be entitled to seek costs or attorney fees.
Certainly, Your Honor. Thank you very much.
Yes, sir. Have a good day. Thank you for
You too. Thank you.
off the record. Mr. Voorhees,
Yes.
I signed a stipulation in order dismissing this case yesterday.
Okay. Do you have that in a copy of it in front of you, Your Honor?
I don't. It would have been sent down to the file room yesterday.
I never gave my permission to sign my name to that because they just gave me the documents on Monday. So I will obviously deal with that firm because that's a kind of an ethical violation. So, okay, that's fine. I was going to inform you that we did said I was going to ask for a control date originally to get the paperwork through. So I will deal with that on my,
Okay.
Thank you.
All right. Have a good day, sir.
You too. Thank you, Your Honor.
That concludes our docket for the day.